Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza. Today we're going to discuss a new appellate decision that's published setting precedents for the future. Can police in New Jersey, if we have a subject in custody and he invokes his right to silence, can we then ask for consent to search? This is our new published opinion, State versus KH. This is a New Jersey Appellate Division published opinion decided June 3rd, 2025. We can't discuss this case without going back to a case we broke down a couple of months ago. This is State versus Frank Ameng. This was a published opinion on March 31st, 2025. Again, that is on our YouTube channel if you want the full breakdown. But we established a bright line rule in New Jersey. If a subject invokes their right to counsel, they are also invoking their right to counsel to not only questions pertaining to an interview, but also they have the right to speak to counsel about any other evidence gathering techniques police are going to employ during that case, which includes a consent search. So if we have a defendant invoke their right to counsel, we cannot then ask them for a consent to search whatever it is that we're looking to search, whether it's a home, a car, etc. In today's case, State versus KH, we're going to see if the courts decided, does that also apply when they invoke their right to silence? Let's get into the details of this case. The defendant, KH, appeals from his jury trial convictions for aggravated sexual assault and burglary. The defendant claims that his consent for a buccal swab test was coerced because it was induced by a quid pro quo promise to release him from police custody. He also argues it was unlawful for detectives to seek his consent after he had invoked his Miranda rights. The detective informed the defendant that he was accused of sexual assault. When the detective asked the defendant whether he would agree to answer questions, he declined and invoked his right to remain silent. He at no point asked for counsel in the video. The defendant remained in police custody. Later that day, a different detective obtained the defendant's consent for a DNA sample. A forensic scientist with the State Police Laboratory examined the swabs that the forensic nurse had taken and found sperm cells on both the vaginal and cervical swabs. Using a DNA profile developed from the defendant's buccal swab, a second forensic scientist determined and testified that the sperm cells belonged to the defendant. The defendant contends that the state failed to prove that he knowingly, intelligently, and voluntarily consented to the buccal swab, claiming he was coerced because the police offered him a quid pro quo deal to release him from custody if he granted consent. On appeal, the defendant claims he invoked his right to counsel and the consent is invalid, and the consent is invalid because the detectives implied he would be released from custody after he provides a buccal swab. The court ruled that State versus Ameng only applies when a defendant invokes his right to counsel, not his right to remain silent. The court reviewed tapes and KH never requested counsel, only his right to remain silent. The appellate court credited Detective Cruz's testimony that he did not know if the defendant would be allowed to go home due to the pending charges. The defendant's allegations were not supported by the video evidence, and the consent form itself read, "I have knowingly and voluntarily given my consent to search without fear, threat, or promise, express or implied." The conviction was upheld and remanded for further sentencing. The court also stated in their ruling that officers really need to understand whether the person is invoking their right to remain silent or their right to counsel. That makes a huge difference on the outcome of this. They further stated that although this information might be found by reviewing an electronic recording of the Miranda colloquy, it would make more sense to memorialize in writing the specific nature of the invocation of Miranda rights. The appellate court recommended to the Attorney General and to the County Prosecutors Association to consider whether standardized Miranda forms should be revised to facilitate the documentation of whether an arrestee asserted the right to confer with counsel, the right to remain silent, or both rights. In summary, the consent to search after invoking the right to silence is proper and admissible as per this case, State v. KH. The consent to search after invoking the right to counsel is a no-go, and all statements will be suppressed as stated in State v. Ameng. I just want to hit on the point about the consent with respect to it being coerced. If we show any type of coercion and the quid pro quo that they discuss specifically in this case, meaning that we will release you if you give us that buccal swab, that will mean that the consent search is involuntary and it will be presumed invalid. It could all be suppressed. The same prongs that we look at for Miranda are the ones that we look at for consent. Knowingly, intelligently, and voluntarily. You cannot coerce people. You absolutely cannot tell somebody that if you give me something, I will give you something. That quid pro quo, that will be deemed improper. Thankfully, in this case, the argument that was brought forward by the defendant was reviewed by the state, and they said there was no coercion. Excellent job by Atlantic City police officers and detectives in getting a conviction for a sexual assault. If you have any questions about this case or anything else, please leave those comments below. Until next time, stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free, only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.